yes, in this new CBA, the licensing or the identity rights of retired players have been contracted out of the CBA. The retired players no longer, or at least the retired players now, will not have the ability going forward to contest the use of their images in the future. I'm sure most, well, maybe not most of you guys, but maybe not most retired players, many retired players are familiar with the fact that if they want to use their picture when they play football to promote maybe a business that they have, that they've probably caught considerable hail from the NFL, that they can't do it. You have to pay for the ability to use your identity in a commercial way. But then you try to figure out, well, why is that? Why do I have to pay for it? Why can't I just use it? And it's because the NFL will contend that they own the rights to that. And that's pretty much the genesis of this lawsuit. But let me speak about a few of the notes that I made here. On August 20th, 2009, there were 6 plaintiffs who filed a lawsuit against the NFL. They're Fred Dreyer, Elvin Bethea, Dan Pastorini, Jim Marshall, Joe Sensor, and Ed White. That case is called Fred Dreyer et al. Versus the NFLPA, and it's brought on behalf of all former retired NFL players. Dreyer is brought by retirees against the league, particularly NFL films, for the unlawful use or licensing of retiree name, image, and likenesses after the date of retirement. The case is pending in Minnesota, and this case will turn on a court's interpretation of copyright law and trademark law, as well as antitrust law, now that the new lawsuit has been filed with this. Essentially what's involved is that retirees are right to a share of the licenses entered into by the NFL with any third party in connection with the royalty received by the NFL, which uses the name, image, or likenesses of a retiree. This case could provide 2 types of recovery. If there's a judgment, there'll be an amount of money reflecting the value of the prior use by the NFL of the retiree's name, image, or likeness. If there is an injunction, there will be an injunction against the continued licensing by the NFL of retiree names, images, and likenesses without sharing that license revenue with the retiree. The value of these things have not been estimated, but we feel they present some realistic exposure to the NFL, particularly at a time when they want to expand the media's use of name, image, and likenesses. The NFL could also choose for this lawsuit to add both individual restitution as well as a general outreach to retirees via increased benefits on an aggregate basis throughout the retiree community. This case has already survived a motion to dismiss, which is huge, and it's set for trial late this year or early next year. The only other big development in this case is that other plaintiffs filed cases in this matter. Fred Barnett and Tracy Simeon, and that case was titled Barnett et al. Versus NFL. That was filed July 5th, 2011. Darrell Thompson, and that's NFL. And then you have Henry Crockett, Crockett versus NFL. The court consolidated those cases with the Dreyer action in November of last year. And then on September of last year, the court appointed 3 firms as co-lead interim counsel. Those 3 firms are Bob Stein, Hausfeld, and Zimmerman Reed. And our firm, Zell Hoffman, is also counsel on those cases. So like I said, that's just a brief update on that.
Weren't we trying to get Zimmerman and Reed off?
That's right.
How does that work?
Well, there was a huge issue there. I think probably you're familiar.
Can you repeat the question so we didn't hear it?
Sure. His question was, weren't we, assuming retired players, trying to get Zimmerman Reed off of that case. Zimmerman Reed is a firm in Minneapolis, and there were some allegations that Zimmerman Reed, I guess I can't get into specifics, but there were just allegations that they were not proceeding in the best interests of the clients.
We're selling us out. No money. We're trying to get that lump sum. I talked to Bob about it, and he was saying that they were saying that there's no way.
Sorry about that. I talked to Bob. No way that we would be able to get a lump sum money as payments for the rest of our life, which I were $300 million. How much our films were? Why couldn't we? But now, when I talked to him last, he said that they have gotten rid of Zimmerman and Reed, trying to, get us everything that they can. What does that mean, though? You know what I mean? Everything, the monthly payments for the rest of our life?
Right. Well, to address the first part of that, Zimmerman Reed is still on the case, and this was something that was decided by the court. Bob Stein fought vehemently and on behalf of the plaintiffs, and his contention was that Zimmerman Reed should be removed entirely from the case. That's not his decision, unfortunately. These guys, because what happened was Zimmerman Reed, when they felt that there was going to be some pushbacks from the initial clients, they went out and they found other clients to file. And then the court had to then make a decision that's in the best interest, not from the original plaintiffs, but from everyone in the class. And ultimately that decision was that Zimmerman Reed would stay in, but Zimmerman Reed would work in a three lead counsel. So they would be one of the three, and the other two, like I said, Bob Stein is one, and then Houseville LLP is the other. As far as the relief that we're going to try to get from this case, we would all like to have a lump sum, incremental revenues going forward, and that's still a possibility.
Why would I mention it to him before he looked at this? No way possible for that. I was in my conversation, he's like, can we get this? He's like, I don't think so. Maybe Zimmerman and Reed. But then Bob brings Zimmerman and Reed on.
Yeah. Then Bob Stein brings Zimmerman and Reed on to represent us.
Yeah, initially.
So he brought them on, and they turned out to be sellouts. So what's really going on? I don't understand. That's what I'm saying. What's going on? Why would Bob bring them on, and then they try to sell us out like that? And I mean, that's just keeping it real,
Right. Well, I believe actually the lead plaintiffs in the case, I'm not sure if every one of them, but if it was not 5 out of 6, it was 4 out of 6, something like that, filed petitions to have Zimmerman Reed removed from the case. However, said they brought in other clients, and the court had to make a decision what was in the best decision of the class, or best interest of the class. And ultimately, without going into a big fight, because it was set up to be a big fight, they thought it was going to be in the best interest of the class to go ahead and just settle the lawsuit quickly. To settle the leadership issues quickly.
But they're not the head counsel anymore.
Well, it's a 3-tiered structure, so if 2 of the law firms agree with each other, they run the case, pretty much. Anything else? All right. I think we're done.
Okay, let me ask you one thing. I remember when Zimmerman Reed sent the thing for us to sign, and I tried to get some other players to sign. If you read it real closely, they said we'd be responsible for legal fees and stuff, and that's why I was so happy that Michael so yeah, so it cost me anything.
Yeah, that's usually something I believe that's standard in many class representation agreements. If you're going to participate in a class action, not necessarily as a class plaintiff, but just participate in that class action, and all of the agreements that that plaintiff will be responsible for, any costs or fees, anything like that. But I don't know how frequently those are ever asserted. So I wouldn't worry about that.
Shawn, there's a lot of lawsuits involved in how many?
My firm is involved in the ones that are currently ongoing in the Eller versus NFLPA lawsuit and the Dreyer versus NFLPA lawsuit. Well, we're tangentially involved in the concussions, but Michael Hausfeld's firm is primarily handling the concussions, at least with just these firms. I think Jason Lukasevitz and some other people here actually have concussion cases.
This might be a silly question, but I have no background in law. But with all these lawsuits going on, is there, as far as settlement, what's the trade-offs? I mean, do the suits get settled together or totally independent of one another as they progress through the process?
I think that's a good question. Normally, it would be, the suits would get settled individually. However, because most of these cases are against the NFL, just one against the NFLPA, but because the combination of these cases produces significant exposure for the NFL, there then becomes more motivation part to come up with, to have a global settlement.
Okay.
And
there's some potential for that?
definitely, yeah.
And then that's where a wrong law firm that could make the wrong be disadvantageous to us at the level maybe?
For that to happen,
Thank you.
yeah. All right, is that it?
Good job. Thank you.
So-